My name is Jeffrey L.G. Johnson. Today's date is December 31st, 2012. This is our second interview pertaining to Johnson et al. Versus the United States et al., pending in the 8th Circuit in the city of St. Louis. The case is about criminal violations, civil rights violations, as well as denial of due process, denying our deceased mother the right to possess property as well as her civil rights violations. The question is this: why would the 8th Circuit Court of the City of St. Louis will be in possession of facts and evidence, but yet turn a deaf ear and continue in corruption? Why would the United States Supreme Court be in possession of 2 waivers of default issued by the United States government, one in 1991 and the other in 2011, and they continue in their corruption? Why would the first African American president and the first African American Attorney General fight so vigorously to deny Johnson et al. Versus the United States et al. The right to a trial by jury, a right that is afforded to every African American as citizen of this country according to their law? The answer is simple. The lawbreakers, or the lawmakers or the lawbreakers in this case, the system will be on trial. At this time, I'm going to introduce to you the proxy of the family, Joseph Johnson.
Yes. The issue actually that's before everyone is that the Constitution. It was the first compact, or what you would consider a contract between those that are chosen and elected to govern and to govern we the people. Under this compact or contract, the Constitution states that the Congress makes the rules for the government. It also states in Article 1 that the Congress can enact any law necessary and proper to maintain civil rights guaranteed under the United States Constitution. The President of the United States, in Article 2 of this compact, he swears an oath to faithfully defend and preserve the Constitution of the United States. He also says that he will faithfully execute the laws of the United States as passed by Congress under Congress's Article 1 powers. Under the federal judiciary, under this same compact, they're required to act under the law with equity, which means that the court doesn't make the rules nor enact laws. They simply have to rule on laws passed by Congress. In Johnson et al. Versus the United States et al., the issue is very plain. The Attorney General of the United States, who is the chief law enforcement officer of the United States government representing the federal government, he issued 2 notifications by the Justice Department, the Executive Office of the United States Attorney, acknowledging, one, that on February 24, 2010, the NSA was involved in a conspiracy to violate civil rights. And in a second notification dated July 23, 2009, he also acknowledged that the CIA was actively involved in a spying program against U.S. citizens, which was prohibited under federal law enacted by Congress. Under the Foreign Intelligence Surveillance Act, it states that the Chief Justice of the United States Supreme Court, the Attorney General H. Holder, and the Director of National Intelligence, Clapper Alexander, were in fact had knowledge of the existence of this spying program, but failed to order a cease and desist to that program under the current administration of President Barack H. Obama. So basically what we have is that the first African American president of the United States and the first person to be elected Attorney General of the United States, also being an African American, are currently involved in an ongoing conspiracy to violate civil rights. as enacted under the 1866 Civil Rights Act, all persons within the United States have the right to file suit for the privation of their civil rights. Congress enacted the 1866 Civil Rights Act to give all persons the right to file suit in the United States District Court for vindication of violations of their civil rights. The Supreme Court in two court cases, in Griswold versus United States and Eisenstadt versus United States, the Supreme Court held that the Liberty Clause of the 14th Amendment guaranteed all U.S. citizens the right to privacy. And then Katz versus United States, the court went further that private persons had the right to be secure in their private communications, whether it's telephone communication, cell phone communications, were free from infringement by the United States government. As previously stated, the Attorney General in two letters has acknowledged the existence of a spying program which violates federal law. Congress enacted the 1986 Act, Section 2521, directing the Attorney General in the event of Title III felonies which the CIA and the NSA has engaged in as authorized by the Office of the President, that the Attorney General was supposed to enjoin with the District Court to bring about a federal remedy to civil rights violations involving Title III felonies. Upon filing suit in the District Court of the 8th Judicial Circuit under the 1866 Civil Rights Act, 5 judges of the Federal 8th Circuit issued 5 separate judgments. Chief Judge Catherine D. Perry issued an order on December 14, 2010, dismissing a case involving a criminal admission by the defendant as frivolous under 28 United States Code 1915. District Judge Rodney W. Simple on June 3, 2011, he also dismissed the claim as frivolous, citing 28 United States Code 1915. On May 23, 2012, District Judge John A. Ross, he also issued an order dismissing the complaint as frivolous, also citing 28 United States Code 1915. On November 20th, United States District Judge Charles A. Shaw, he also issued an order dismissing the civil complaint as frivolous, also citing 28 United States Code 1915. On December 10th, United States District Judge Audrey G. Fleischman also issued a 5th order dismissing the complaint as frivolous, citing 28 United States Code 1915. Out of all of these 5 orders issued, 3 judges, Judge Perry, Judge Simple, and Judge Ross, executed within their orders that they not execute service to the Attorney General of the United States, who was required by law under the 1986 Act 18 United States Code, Section 2521. Congress authorized him to enjoin in the federal district court to bring about a federal remedy to Title III felonies. When Judge Perry, in her order, Judge Simple, in his order, and Judge Ross, in his order, ordered the clerk not to execute service to the Attorney General, all 3 federal judges violated federal law enacted by Congress, which means that under Article 3, all 3 federal judges failed to perform their duties of office based upon good behavior, and therefore they were subject to impeachment by the judiciary committees of the House and the Senate, for which it has subsequently been disclosed that the Attorney General, instead of enjoining in the court as required by federal law, he was secretly meeting with the intelligence committees of the United States Senate under the same rules in which he was provided by law to enforce under the Foreign Intelligence Surveillance Act. he met with Senator Feingold as a means to tweak the Foreign Intelligence Surveillance Act, otherwise known as FISA, which authorizes the United States government to spy on persons outside of the United States, not inside of the United States. The Attorney General violated federal law when he did not go into the district court to answer the allegations relevant to the spying program authorized by the Executive Office of the President of the United States, commencing with Ronald Reagan in 1988, which was continued by President George H.W. Bush, President William Jefferson Clinton, George H. Bush, and now President Barack H. Obama. The fact of the matter is, the courts, in dismissing and not summoning the Attorney General to court to answer the allegations of the spying program admitted by the Justice Department, both the United States Office of the Presidency and the federal judiciary have engaged in a conspiracy to conceal criminal conduct by the United States government from we the people, violating the compact, i.e. contract, the Constitution of the United States, between those who implement the laws and those who have to follow it. In one instance, just to let you know about the corruption that runs rampant within the Eighth Circuit, the Chief Judge of the Court of Appeals, one William J. Riley, he issued an order of a complaint entered by us contesting that federal judges were actually in the process of violating federal law enacted by Congress, which displays bad behavior, which would subject them to impeachment. On December 12, 2012, William J. Riley, the Chief Judge of the Court of Appeals, issued an order to the conduct complaint. I'm going to quote you a little section from his order. He stated, although allegations of conspiracy, malice, dishonesty, judicial bias, prejudice, or other improper motives or conduct are not necessarily merit related, such allegations must be dismissed as merit related when, as in this case, the only support for the allegations is the merit of the judge's rulings. If you would keep in mind the admission by the Justice Department of the existence of the spying program, which had absolutely nothing to do with the orders that Judge Riley is speaking of in dismissing the complaint up against the 5 judges who dismissed the complaint. The fact of the matter is, put this simple, if 1 + 1 = 2, then if CIA plus NSA equals spying, just what did judges of the Federal 8th Circuit think that the NSA and the CIA does for a living? They spy. So the facts were not based upon anything that was merit related to any of the orders entered by the 5 judges. Putting it real simple, this is the simplest way to put it. If a person intentionally sets their home on fire and then calls the fire department, the fire marshal arrives and determines that the fire was arson. The person who subsequently started the fire can then turn around and say he shouldn't be prosecuted as an arsonist simply because he called the fire department. In this instance, Judge Riley is saying that just because the judges entered orders, all their prior conduct became moot. Regardless of whether, like he said, regardless of whether it was a conspiracy, malice, dishonesty, judicial bias, prejudice. That is just like saying that there's an old saying that Justice Thomas once used. He said the Constitution under the 14th Amendment only guarantees you the right to an impartial judge, but it doesn't guarantee you the right to a fair trial. That is just like saying if you got on the bus and the bus had an accident, you are actually responsible for the accident simply because you got on the bus, and not that the bus driver or a third party may have caused the actual accident. So basically what the federal court has engaged in is, with the office of the presidency of the United States, is a conspiracy to violate the Constitution of the United States, which is tantamount to treason. And the drafters of the Declaration of Independence declared these kind of individuals as tyrants. We're not saying that. The drafters of the Declaration of Independence have declared that these persons are actually tyrants. And Judge stated in his order that us complaining like this, that it's malicious. Well, when in fact, it is basically malignant, which means a process of where you actually pursue justice in earnest. It is not malicious to state facts against people who are violating your rights. We stated to District Judge Ross, if anything that we have said is malicious, then all those parties should have been come forward within the last 25 years to sue us. But there hasn't been one person cited as the defendant in our case who has voluntarily came forward to file suit against us. And the Attorney General is behind closed doors in the wrong venue. The Judiciary Committee of the House and Senate has jurisdiction over the conduct of federal judges, the Constitution, and the enforcement of federal laws. He had a responsibility to plead the government's case in the district court, and he failed to show up. And we want to thank you for your time.